Thank you so much. At this moment, I would like to yield to my colleague, the Honorable Donald Payne from New Jersey's Congressional District.
Mr. Speaker, I'd like to thank the gentlelady from Florida for giving me the opportunity to speak on this issue tonight, and also my colleague, the gentleman from Illinois. I rise today to discuss the U.S. Supreme Court's horrible decision to reject affirmative action in college admissions. Last month, the court ruled that affirmative action programs in college admissions violated the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. But that ruling opposes decades of Supreme Court decisions that said just the opposite. They said that the issue of race as an admissions factor was consistent with the 14th Amendment. In 1978, the court said that institutions of higher learning had the right to pursue a diverse student body to advance academic freedom. And they could consider race as a factor to evaluate college applications if it was one of many factors. In 2003, the court reaffirmed this ruling because students of African Americans and other minorities had looked at this issue for quite some time, and it was working. In public universities nationwide, minority enrollment increased when race was one factor of admissions. And these minority students equaled or exceeded the successes of their white peers in a variety of academic fields when they graduated. Today, these policies help foster a rich and diverse environment for all Americans in higher education. And they help minority students secure higher paying jobs in STEM fields, such as engineering and science. But the Supreme Court has decided that this type of equality is bad for America. It wants to reject the fact that race has been a factor in college admissions for decades. Unfortunately, it was used as the only factor to reject candidates, and not one of many factors to consider when accepting them. I'm outraged that the Supreme Court has rejected a successful policy that has helped millions of Black and other minority students receive the quality education they deserve. At one time, they weren't allowed to enter these schools. And what was the reason? Was it many factors that they could not attend these schools? No, it was one factor: their race. It is yet another indication of how our country is slowly returning to a time when equal opportunities were not afforded to all Americans. The court said that race-related admissions standards violated Equal Protection Clause. But where was that Equal Protection Clause during slavery and Jim Crow? Where was that equal protection today in housing, workforce hiring, and voting rights? Conservative justices and politicians want to pretend that our country has no racial issues. They are not connected to reality in that thinking. This decision is yet another roadblock to success for Black Americans in this country. But we have overcome them before, and we'll overcome them again. And I will continue to fight to help us overcome these roadblocks wherever we find them. And we will not stop until we have racial justice and equality for all Americans in this country. And with that, Mr. Speaker, I yield back.
Thank you so much. I would like to yield to my colleague, the Honorable Jamal Bowman from New York.